created an uncomfortable situation where, in essence, there is a possibility of the petitioner enjoying two bites at the cherry, as it were. Perhaps more importantly, the petitioner's choice of crafting two distinct petitions with minimal overlap, such that consolidation would not be automatic, has had the consequence of denying a single court a bird's-eye view of the entirety of the process, from the inception at the County Assembly to the Senate resolution, and thus forcing two High Court stations to tread carefully so as not to stray into the other's case. To be clear, this was not forum shopping, but rather it was clever lawyering, where the petitioner's counsel identified a loophole that they could use to the benefit of their client. By drafting and filing a petition before this court in which all the allegations were limited to the Senate stage, and by only suing the Senate Speaker, perhaps fully aware that the County Assembly and its officers would be forced to join the proceedings through applications for joinder, the petitioner has created a situation where she now has two opportunities for success rather than just one. As discussed earlier under the limb of the court order and whether it was violated, this court is limited by the amended petition to only the Senate stage aspect of that limb, with the petitioner still having another opportunity in the County Assembly stage challenge of the same limb, which is pending before the High Court in Meru. As we continue to fine-tune the practice and process of litigation in the High Court on the subject matter of gubernatorial impeachments, this is certainly a loophole that must be firmly closed by the courts in future impeachments, if a similar situation were to arise. This would not only make adjudication of the dispute more wholesome and comprehensive, but it would also ensure that all the petitioner's grievances are laid before a single court, which would be able to take a holistic view of the matter rather than being constrained to a more limited view. Therefore, while the constitutional validity of Section 33, subsection 8 of the County Government Act poses legitimate legal questions, both in favor of and in opposition of its constitutionality, this court declines to determine the same within this judgment, as the same is pending before the Meru High Court in a related matter which was filed earlier in time. Whether the threshold for public participation was met in the impeachment process. The issue of whether the threshold for public participation was met in the impeachment process is central to the petitioner's argument that the impeachment proceedings were unlawful. Public participation is a constitutional requirement under Article 10, Clause 2, Paragraph A, and Article 196, 1B of the Constitution of Kenya 2010, which mandate inclusive and meaningful citizen engagement in government decision-making, including legislative processes such as impeachment. However, public participation in impeachment proceedings primarily occurs at the County Assembly level rather than at the Senate level, since the County Assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for the final determination. The petitioner contends that the public participation process was inadequate or manipulated, thereby rendering the entire impeachment invalid. However, the respondent and the interested parties who support the respondent maintain that public participation was conducted in compliance with legal requirements, and any challenge to its inadequacy should be directed at the County Assembly rather than the Senate. Once more, this court is treading delicately so as not to stray into the province of a petition that is pending before the High Court in another station, and thus refrains from an in-depth analysis and determination of this issue, despite the parties having canvassed it at great length. This situation, as stated earlier, is a direct consequence of the drafting and filing choices made by the petitioner, which resulted in two live but distinct petitions pending before the High Court sitting at Meru and sitting at Milimani, Nairobi. Given that the petitioner has not sought adverse orders against the County Assembly, the court finds it procedurally improper to determine this issue in the present petition, as it is already being addressed in a separate case before the Meru High Court, in which the matter of public participation is at the core of the petitioner's grievance against the County Assembly. For the purposes of this amended petition, it is the finding of this court that the amended petition has not shown a correlation between its allegations on public participation and justiciable grounds against the respondent and the Senate within the four corners of the amended petition that is before this court. The next issue, whether the threshold for impeachment of the petitioner was met. The question of whether the threshold for impeachment was met revolves around two key legal considerations: whether the charges against the petitioner constituted valid grounds for removal under the Constitution, and whether the High Court should conduct a merit review or a process review of the impeachment decision. The petitioner and the interested parties who are in support of the amended petition contend that the allegations against her did not amount to gross misconduct, abuse of office, or gross violation of the Constitution, as required under Article 181, Clause 1 of the Constitution. On the other hand, the respondent and the interested parties who oppose the amended petition argue that the charges presented before the Senate were serious and substantiated, thus meeting the legal standard for impeachment. The Constitution of Kenya 2010 under Article 181 Clause 1 states that a governor may be removed for office for 1. Gross violation of the Constitution or any other law; 2. There being serious reasons to believe the governor has committed a crime under national or international law; 3. Abuse of office or gross misconduct; or 4. Physical or mental incapacity to perform the functions of the office. These requirements are mirrored in Section 33 of the County Governments Act, which outlines the procedure for impeachment, requiring an initial resolution by the County Assembly followed by a Senate hearing and vote. The Senate is tasked with evaluating the sufficiency of the charges and determining whether the evidence meets the constitutional threshold. Courts have consistently ruled that impeachment is not a purely political process, but one that requires objective and verifiable evidence of wrongdoing. Several landmark cases have clarified the legal threshold for impeachment, reinforcing the principle that impeachment must be based on substantive proof of serious wrongdoing. In MATIANG'I versus Speaker of the Senate and others 2014, the Court of Appeal held that impeachment must be based on evidence of gross violations of the law, not on minor procedural errors or political differences. The decision emphasized that governance mistakes or administrative inefficiencies do not automatically amount to gross misconduct warranting removal from office. Similarly, in Governor Ferdinand Waititu versus County Assembly of Kiambu and the Senate 2020, the High Court ruled that impeachment should not be misused as a tool for political maneuvering, but must be based on serious and substantiated allegations. In another seminal case, Mike Sonko versus County Assembly of Nairobi and Senate 2021, the Supreme Court clarified that the threshold for impeachment requires proof of gross misconduct and significant breaches of the law. In the current case, the Senate reviewed the allegations against the petition and found that they met the threshold for gross misconduct under Article 181(1), meaning that the charges were serious enough to warrant removal. Applying this principle, if the Senate found the allegations against the petitioner to be serious, backed by evidence, and meeting the constitutional standard, the impeachment should stand. A crucial legal question in this case is whether the High Court should conduct a merit review, reassessing the correctness of the charges and the evidence, or a process review, assessing whether due process was followed. Courts have consistently ruled that judicial review of impeachment should focus on ensuring procedural compliance rather than assessing the merits of the charges. In the Supreme Court case of Peter Munya, the Apex Court emphasized that judicial intervention in constitutional processes should be limited and should focus on procedural fairness rather than the correctness of legislative decisions. Similarly, in Wambora versus Speaker of the Senate and others, Supra, the Court of Appeal held that the High Court's role in impeachment cases is to ensure that the process followed the legal and constitutional requirements rather than substituting its own judgment on the allegations. The Supreme Court further reinforced this position in Sonko 2021, where it ruled that the Senate and County Assembly have the constitutional authority to determine impeachment matters, and courts should only intervene where there are clear violations of due process. Applying these principles to the present case, the High Court is not required to assess whether the Senate made the right decision, but should only determine whether the procedure followed was fair and constitutional. A proper reading of these decisions in light of the Constitution requires that this court can only engage in a merit review of the decision of the Senate if the decision of the Senate on the applicable law and/or evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, notwithstanding the procedural compliance of the process. This court is satisfied that the charges laid before the Senate and which were considered by the Chamber in favor of impeachment were of a nature that meets the requirements of Article 181, Clause 1 of the Constitution, and the petitioner has not shown that the Senate's analysis of the applicable law and evidence was so profoundly incorrect that no reasonable quasi-judicial body properly applying its mind to the law and the facts would have arrived at that conclusion, and thus warranting interference by this court. With regard to the procedural and due process probity of the Senate's processes, this court notes that the unique circumstances of this case and the manner in which the parties canvassed the question of fair hearing require that the same be analyzed separately and not as part of an omnibus procedural and due process examination. In that regard, while the court finds that the procedural and due process boxes were ticked in the Senate, the question of whether there was a substantive fair hearing in the Senate shall be dealt with separately and below. The right to a fair hearing is a fundamental constitutional guarantee enshrined under Article 50 of the Constitution of Kenya 2010. The petitioner claims that her impeachment was invalid due to the alleged violation of her right to a fair hearing during the Senate proceedings, a position supported by the first, second, and seventh interested parties, but strenuously opposed by the respondent and the third, fourth, fifth, and sixth interested parties. The relative positions of each of the parties on this issue were extensively set out earlier in this judgment, and thus there is no need to repeat them here.